दोस्तों नमस्कार। दोस्तों, कल मैंने आपसे प्रॉमिस किया था कि मैं ज्ञानवापी केस के बारे में एक वीडियो बनाऊंगा, लेकिन कुछ व्यक्तिगत व्यस्तता के कारण मैं उस वीडियो को नहीं बना पाया। इसके लिए मैं क्षमा प्रार्थी हूँ। असल में शुक्रवार के दिन सुप्रीम कोर्ट ने इलाहाबाद हाईकोर्ट के फैसले को बरकरार रखते हुए ज्ञानवापी परिसर में सर्वे को रोकने से मना कर दिया। मुस्लिम पक्ष शुरू से ज्ञानवापी परिसर में सर्वे का विरोध कर रहा है। क्यों कर रहा है वो हम सबको मालूम है। जो हमारे भारत में सनातन धर्मी रहते हैं, हिंदू धर्म वाले रहते हैं, उनको मालूम है कि वो क्यों मना कर रहे हैं। उनको मालूम है कि अगर वहां पे सर्वे होगा तो औरंगजेब के द्वारा काशी विश्वनाथ मंदिर को ढहाने का पूरा साक्ष्य सामने आ जाएगा। ये जग जाहिर सी बात है, दस्तावेजों में अंकित है कि काशी विश्वनाथ के मंदिर को गिरा करके ही औरंगजेब ने वहां पर मस्जिद बनवाई थी। आप खुद सोचिए कि किसी मस्जिद का नाम ज्ञानवापी क्यों हो सकता है, कैसे हो सकता है। वहां पर नंदी शिवलिंग की तरफ को अपना फेस करके क्यों बैठे हुए? वहां पर त्रिशूल और दूसरे कमल जैसे आकृतियां दीवारों में क्यों हैं? इसके मतलब वहां पर मंदिर था। सवाल ये उठता है कि हिंदुस्तान की पूरी सामाजिक संरचना को इन आक्रांताओं ने नेस्तनाबूद करने की पूरी कोशिश की, लेकिन कुछ शक्तियां हैं जो हिंदुस्तान के सनातन धर्म को बचाने में कामयाब रही। 712 में जब मोहम्मद बिन कासिम सिंध के इलाके में आया था से लेकर के ये लोग प्रैक्टिकली हमेशा यहाँ पर दारे इस्लाम कायम करने की कोशिश करते रहे। जितने भी यहाँ पर सनातन धर्म के मंदिर थे उनको सबको तोड़ा गया। बख्तियार खिलजी ने तो जाकर के नालंदा में पूरी जो यूनिवर्सिटी थी उसकी जो किताबें उनको जला दी थी। ये जैसे कि हो रहा है कि पाकिस्तान में आज की डेट में कोई भी मंदिर शायद बचा नहीं है। इवन कश्मीर में भी कोशिश कर रहे थे कि मंदिर को तोड़ दे, सिर्फ जहां पर भी रहे सिर्फ अल्लाह ही रहे, ये करते हैं। तो इस परिप्रेक्ष्य में सुप्रीम कोर्ट के आदेश को मैं आपको थोड़ा सा पढ़ के बताता हूँ या एनालाइज करके बताता हूँ। जो लाइब्रा ने रिपोर्ट किया है, मैं स्ट्रेट बोल रहा हूँ कि लाइब्रा की रिपोर्ट को मैं आधार बना रहा हूँ और उसके हिसाब से आपके सामने प्रस्तुत कर रहा हूँ। ये लाइब्रा की रिपोर्ट है, देखिए अगर आपको दिख रही है तो ये देखिए। सुप्रीम कोर्ट अलाउज एएसआई सर्वे ऑफ ज्ञानवापी मॉस्क विदाउट एक्सकेवेशन ऑफ डैमेज टू स्ट्रक्चर। ये देखिए पूरा, मैं इसको ऑन कर देता हूँ, सुनिए क्या बोल रहे हैं।
The Supreme Court on Friday refused to stop the Archaeological Survey of India (ASI) to survey the Gyanvapi Mosque at Varanasi, taking on record an undertaking made on behalf of the ASI that no excavation will be done at the site and no damage will be caused to the structure. The court allowed the survey to take place. Accordingly, the court disposed of a petition filed by Anjuman Intezamiyar Masjid Committee, which manages the Gyanvapi Mosque at Varanasi, challenging yesterday's Allahabad High Court order which permitted the ASI survey. It is clarified on behalf of the ASI by Solicitor General of India Mr. Tushar Mehta that as a matter of fact, the entire survey will be completed without any excavation at the site and without causing any destruction to the structure. recorded the order passed by the bench comprising Chief Justice of India D. Chandrachud, Justice J.B. Paradiwala, and Justice Manoj Mishra. The order of the learned trial judge passed under Order 26 Rule 10A of the CPC cannot be prima facie at this stage to be said as without jurisdiction, the bench noted in the order. The bench noted that the evidentiary value of the scientific commission is open to be tested in the suit and is open to objections, including cross-examination. Hence, a report of the commissioner, by itself, does not amount to a determination of the matters in dispute. Having regard to the nature and ambit of a court-appointed commissioners, we are unable to differ with the view of the High Court, particularly in the jurisdiction under Article 136, the bench observed. In addition to the undertaking by the ASI, the court directed that the ASI survey should be carried out through non-invasive processes. The report which will be prepared by the ASI shall be remitted to the trial court and shall thereafter abide by the directions which will be passed by the district judge. The bench was considering two special leave petitions SLP filed by the Masjid Committee, one filed against an order of the High Court dismissing their petition filed under Order 11 Rule 11 CPC to reject the plaint as barred by the places of worship. 2. Petition filed against the order allowing a survey of the structure. On the first SLP in respect to the Order 7 Rule 11 issue, the bench issued notice to the Hindu plaintiffs and posted the matter for hearing on a later date. The second SLP was disposed of in terms of the directions mentioned above, recording the undertaking of the ASI. Arguments. When the matter was taken, CJI Chandrachud told the petitioner's counsel Senior Advocate Hosaifa Ahmadi that the High Court has taken on record the ASI's affidavit which state that they are not carrying out any excavation. Ahmadi however argued that the very process is barred by the Places of Worship, Special Provisions, Act 1991. By ordering the survey, and by going back in the history as to what happened 500 years ago, are you not violating the Places of Worship Act? Ahmadi asked. CJI said that this issue will be considered while hearing the main matter regarding the maintainability of the suit. Ahmadi urged that the survey totally impinges upon fraternity, secularism, and statements of objects of the Places of Worship Act. But Mr. Ahmadi, this is an interlocutory order appointing a commissioner. Why should the Supreme Court interfere? We will keep open all issues regarding maintainability, objections to commission evidence. These are matters to be argued in the suit ultimately. You must treat it like any other suit, CJI said. But this has the propensity to, Ahmadi said. Even in the Ayodhya case, a great deal of argument was made on the evidentiary value of a survey. These are issues to be addressed at the final hearing as to what is the evidentiary value of the survey. We will safeguard the structure, CJI said. Will you ask the ASI to do survey as a matter of course? Ahmadi asked. If I make out a case that the suit is not maintainable, where is the question of survey? I am saying don't have the survey when there are serious doubts on the maintainability, he argued. CJI however said that the power of a civil court to pass ad interim orders is not barred merely because maintainability is questioned. He pointed out that two courts have held in favor of the suit's maintainability. We will safeguard your concerns by protecting the structure, CJI told. Solicitor General of India Tushar Mehta undertook that no excavation will be carried out and the ASI will follow the stand taken before the High Court. These are sly methods. The process is such that you are reopening the wounds of past. When you start a survey, you are unraveling the wounds of the past. And it is the very same thing the Places of Worship seeks to prohibit, Ahmadi urged again. Justice Paradiwala then said, consider it from a different angle. Your principal argument is why undertake the survey when the suit's maintainability is questioned. This survey is going to be in the form of a report. Tomorrow, if you succeed in getting the plaint rejected, this survey will be nothing but a piece of paper. Let the survey take place because of the assurance given by Mr. Mehta that there is no invasive method. Let the report be given in a sealed cover. Ahmadi, summing up his arguments, pointed out that a similar order was passed in a suit which was filed in 1991, which was stayed by the High Court. He also said that there was an earlier order passed by the Supreme Court to maintain status quo with respect to the structure in the order reported as 1994 to SCC 48. Further, A separate SLP is filed against an order passed allowing the carbon dating of the structure claimed to be the shilling inside the mosque, which was kept in abeyance by the Supreme Court in May. Reference made to UP CM's statement. Ahmadi also invited the bench's attention to a statement made by the UP Chief Minister Yogi Adityanath few days ago while the matter was pending. He handed over a paper containing the CM's statement and did not read it out in the court. This was highly unfortunate. The Chief Minister made the statement when the matter was hotly contested and pending. The state is supposed to be neutral and non-partisan, Ahmadi said. Arguments of the plaintiffs. Senior advocate Madhavi Devan, appearing for the Hindu plaintiffs, said that the AC survey is a process of taking expert evidence which will be beneficial to all parties. She said that the plaintiffs have sought for reliefs to worship the visible and invisible deities in the structure. Certain signs and symbols have clearly been seen there. It's logical to reach the conclusion by a scientific study, Devan said. This is an order under Order 26 of the Code of Civil Procedure which will assist the court in deciding the suit. The order is neither adversarial or prejudicial as the rights of the parties are not determined and it will be subject to the objections of the parties. She argued that the Places of Worship Act does not bar the determination of a religious character of a place as it stood before the cut-off date of August 15, 1947. Ultimately it is the AC. Its job is to preserve monuments. So surely they cannot damage it. They know better, Devan said while contending that the right to know the religious character of the structure cannot be barred. She further said that the 1991 suit was a title suit filed on a different cause of action. Salami tactics. In rejoinder, Ahmadi again made reference to the statements of objects and reasons of the Places of Worship Act and also the interpretation given to it by the Supreme Court in the Ayodhya judgment. He voiced the apprehension that there will be further applications in the future, saying that some discovery was made, and they will be slowly edged out of the mosque property. These are salami tactics. There will be applications and applications in future, saying some discovery was made here, allow puja there. All this while it remains a mosque property. Piece by piece, we will be edged out of the property, Ahmadi said. He emphasized that the AC is moving at a lightning speed and they reached the premises today morning at 7:30 a.m., despite knowing that the Supreme Court is considering the matter today. Yesterday, the Allahabad High Court had dismissed the Masjid Committee's challenge to the Varanasi District Judge's July 21 order for a sea survey of the Gyanvapi Mosque. The Allahabad High Court, while permitting the sea survey today, had said the Varanasi Court was justified in ordering for a sea survey of the premises. Scientific survey is necessary in the interest of justice. It may be recalled that the Anjuman Mosque Committee moved the HC on July 25 challenging the order of the Varanasi Court directing the AC to survey the mosque premises, except for Wuzu Khana. This order was by the district judge on an application filed by 4 Hindu women worshippers who are party to a suit filed before the district court seeking year-round access to worship inside mosque premises. The Supreme Court on July 24 stayed the AC survey till July 26, 5 p.m. so as to allow some breathing time to the Masjid Committee to approach the High Court. The stay was extended by the HC on July 27 till August 3.
तो सुन लिया। अब ये है कि सुप्रीम कोर्ट के इस आदेश के बाद में वहां पर एसआई का सर्वे चालू हो गया है। आज की खबर यह है कि तहखाने की चाबी अंजुमन इंतजामिया ने सर्वे टीम को दे दी है और सर्वे टीम जो है उसमें नीचे तहखाने में गई है, वहां पर कुछ मूर्तियां मिली हैं, ये खबर आ रही है। देखो क्या होता है आगे, जो भी होगा बताएंगे, लेकिन एटलीस्ट अच्छा हुआ कि सुप्रीम कोर्ट के चीफ जस्टिस के दिमाग में ये बात आ गई कि हाँ भाई ठीक है, सर्वे को चालू करना है, अदरवाइज वो तो क्या बताएं उनके बारे में, जितना बोला जाए उतना कम है। वो तो चीफ जस्टिस हैं भाई, ठीक है। तो इस बारे में आगे जो भी और डेवलपमेंट होगा, कभी भी कोई डेवलपमेंट होगा, ये बहुत इंपॉर्टेंट केस है क्योंकि इससे आगे और रास्ते खुलते हैं। मथुरा भी बाकी है, मथुरा को भी थोड़ा सा लेना पड़ेगा। अगर ये सर्वे बराबर रहा, अयोध्या ले लिया है, मथुरा ले, काशी लेने वाले हैं, फिर ये हो जाएगा। तो देखो क्या करता है, सब तो ज्यादातर तो सब कोर्ट के ऊपर डिपेंड करता है। अगर कोर्ट हमारी मदद करता है, जो कि कभी तैयार नहीं होता हमारी मदद करने के लिए, मतलब हमारी मतलब सनातन धर्म वालों की, वो हमेशा दूसरे पक्ष की तरफ ही रहता है, पता नहीं क्या बैलेंस करता रहता है। एनीवे, तो ये एक वीडियो बनाना था ज्ञानवापी के ऊपर, जो मैंने बना के दिया। आपको अगर ये वीडियो अच्छा लगता है, इसको लाइक करें, सोशल मीडिया में अपने दोस्तों यारों के साथ में, व्हाट्सएप ग्रुप में इसको शेयर करें, और मेरे चैनल को सब्सक्राइब करें। दूसरे वीडियो का नोटिफिकेशन पाने के लिए बेल आइकन दबा दें। मिलते हैं अगले वीडियो में किसी और मुद्दे के साथ। तब तक के लिए धन्यवाद, नमस्कार, जय हिंद।